Welcome everybody to this month's seminar for the Health Law and Ethics Network at Melbourne Law School. My name's Paula O'Brien. I'm one of the directors of the Health Law and Ethics Network at the Law School. I'd like to start by acknowledging that the Melbourne Law School stands on the land of the Wurundjeri Wurrung people, and I'd like to pay my respects to their elders past, present and emerging. Today's seminar is on Maeve's Law, which passed the Senate last Wednesday night and received royal assent on Friday. So the law has come into force on Friday. We're really delighted that this seminar on Maeve's Law, Science and Ethics is being presented today. We're very pleased to welcome Professor David Thorburn, Professor Megan Munsie and Dr. Chris Gyngell to present today. Each of our speakers will present for about 15 minutes and then we'll have about 15 minutes for questions and answers. We know that's not long given how interesting this new law is, but we hope it'll be a chance to get a conversation started that we might be able to continue into the future. Okay, so I'd like to hand over to David, who is going to start us off today. Thanks, David.
Thanks very much, Paula. So thanks very much for the invitation to speak. It's been an exciting week. I was in the middle of Murrumarang National Park as this was happening last week. Unfortunately, my internet hung together and I could watch the Senate session. So we're going to be talking about Maeve's Law. I should start by saying, as disclaimers, I guess, that I work at the Murdoch Children's Research Institute and Victorian Clinical Genetic Services, and for 30 years have been involved in research and diagnosis of mitochondrial diseases, including in the reproductive aspects. Also have an honorary appointment at the University of Melbourne, and am on the board of the Mito Foundation and its Scientific and Medical Advisory Panel. So this picture is of Maeve Hood and her mother Sarah, and Sarah and Joel visited and lobbied Greg Hunt early on about legalising mitochondrial donation, and that's how it's ended up being called Maeve's Law. So Maeve has a form of childhood onset mitochondrial disease. So I'm going to try to set the scene by discussing the science and the rationale for mitochondrial donation. And I'll just get the laser pointer. And so I think you're all aware that, at least in simplistic terms, mitochondria are the power plants of the cell, and on these very tightly folded inner membrane is the energy generation machinery of the mitochondrion. They're quite complicated wee beasties, so at least 1,200 to 1,500 proteins, unique proteins, are required for the mitochondrion, and so the vast majority of these are encoded by regular nuclear genes. But we have this evolutionary relic, if you like, of mitochondrial DNA that encodes 37 genes, including 13 proteins required for oxidative phosphorylation to be able to generate ATP, the energy carrying molecule. And when we think about the role of mitochondria, I always like quoting this article from Peter Rich nearly 20 years ago now, where he did the biophysical calculations that at rest, the estimate is that a human requires a generation of about 100 kilocalories of energy per hour to remain alive, so about the same as a bright light globe. And in doing that, we're turning over approximately 65 kilograms of ATP per day, so generating and using it. If you were to buy that at your local chemist, that's about a $3 million a day habit. And really relevant to thinking about the implications of mitochondrial dysfunction is that our brain is only about 2% of our body weight, but responsible for about 20% of resting energy expenditure. So that means during this seminar, you're going to be turning over, or your brain is going to be turning over something of the order of nearly 0.5 kilogram of ATP, which would be an hourly rate of $25,000 an hour, which would be pretty nice if you could get it. And the other organs that are in constant use, like heart and kidney, are also huge energy consumers. So what happens when mitochondria don't work? So I've worked at Murdoch Children's for 30 years and been involved in diagnosis of over 600 children with childhood onset mitochondrial disease. The most common single presentation is one called Lee syndrome. Typically kids healthy for about maybe 6 months or so, and then after a viral illness usually undergo a progressive episodic neurodegenerative course, typically dying by about 3 years of age, although there's quite a bit of variability there. And there's this unique radiological picture for classic Lee syndrome with these bilateral symmetric lesions, typically affecting the basal ganglia and brainstem, the primitive regions of the brain, and controlling things like respiratory rhythm and so on. So that sounds like one well circumscribed condition, but we know that there's at least 80 different genes in which mutations can cause this phenotype. So many of them are regular nuclear disorders, autosomal recessive disorders, or X-linked, but about a third of the time it's due to changes in the mitochondrial DNA, so maternally inherited or de novo mutations. So that's one example. But I guess the truism of mitochondrial disease is really sort of any symptom, any organ system, any age of onset, any mode of inheritance. So although neurological symptoms are the most common and found in most patients, you can have isolated involvement of the heart, the kidneys, the liver, and so on, or more commonly multisystemic disease, onset at any age, often very progressive, usually associated with early death and severe disability. So I do want to emphasize up front that this concept of mitochondrial donation, and I'll go into the two main forms that have been used, is only relevant to mitochondrial DNA. And disease-causing changes in mitochondrial DNA were first identified in 1988. And I've got to show the ubiquitous slide of the mitochondrial DNA, and this was meant to be a mutation map as of nearly 10 years ago now. So mutations have been found in nearly all of the 37 mitochondrial DNA genes, which encode 13 of the proteins, a full set of 22 transfer RNAs, because the genetic code is slightly different, and 2 ribosomal RNAs. So almost all of those genes have mutations that can cause human disease. Again, just to mention in passing, really most of the work in diagnosis in childhood onset disease is on nuclear mitochondrial disease genes, and we know of more than 300 genes in which mutations can cause these disorders, but they're not relevant to mitochondrial donation. So mitochondrial DNA doesn't play by the Mendelian genetics rulebook. It has maternal inheritance. That's largely because there's something like 200,000 copies of mitochondrial DNA in the mature egg, only about 50 copies in the sperm. And this nasty, that's not quite the word, anti-misogynistic system, I guess, where the sperm mitochondria are tagged for destruction. So paternal inheritance has really only been demonstrated once in humans as a sort of the outlier that proved the rule. So there are multiple copies of the mitochondrial DNA. So it's not like nuclear disorders where you have 0, 1, or 2 copies of a mutant gene if there's a mutation present. You have a heterogeneous cytoplasm, so you can have 1% mutant mitochondrial DNA, or 10%, or 25, or 50, or 90, or 95%. And perhaps not surprisingly, depending on the mutation, the amount of mutant mitochondrial DNA is critical to whether it's going to cause disease. So you have a threshold effect that very often you might need 90, 95, even 99% of the mitochondrial DNA to be mutant. And in some of the conditions, the mutation is homoplasmic, 100% mutant, and they're typically associated with more variable penetrance, where not everyone will develop the condition necessarily. The other concept that I'll just demonstrate by a couple of pedigrees is the so-called bottleneck. So there's a genetic bottleneck in mitochondrial DNA numbers, appears to be primarily in the primordial germ cell, which means siblings can have vastly different amounts of mutant mitochondrial DNA. And that can change between generations. So I just thought I'd show 2 examples of pedigrees. Here, one, a boy who died in early childhood with Lee syndrome, which I just described, where 99% of his DNA in accessible tissues carried this particular mitochondrial DNA mutation, one of the more common ones. But remarkably, his sister and mother had no detectable mutant mitochondrial DNA. And this is what we believe happens in about a quarter of childhood onset mitochondrial DNA disease, that it appears to be a de novo mutation. So we believe the mother is at low risk of having another affected child, but not 0. And these sort of families, it seems very appropriate to offer prenatal diagnosis or pre-implantation genetic testing. And in the prenatal diagnosis area, the VCGS has done that for about 40 pregnancies over the last 20 odd years or so. And in this scenario, I think there's been about 24 where the mother has had a very low amount of the mutation, and they've all had no mutation detected in chorionic villus or amniocytes. So that's one example where mitochondrial donation would not be relevant. Here's another family, the mother here with a modest low mutant load, family ascertained by a child with the same mutation, a slightly lower amount and a slightly milder phenotype. He's survived into at least his third decade. 3 sisters, 2 of them with very low amounts of mutant mitochondrial DNA. And again, both of those have accessed prenatal testing to confirm they had unaffected pregnancies, but a 3rd sister with a very substantial amount. And prenatal testing or even pre-implantation genetic testing are unlikely to be suitable for a woman with that much mutant mitochondrial DNA, because it's unlikely you'll find levels that are confident to be unaffected. So that's where either egg donation or mitochondrial donation have been suggested to have a role. Just on the epidemiology, the prevalence of mitochondrial disease, or the birth prevalence, best data on childhood onset disease still comes from a paper we published nearly 20 years ago, where we found 6.2 per 100,000 births in a 10-year birth cohort from southeastern Australia. We could basically add that to adult onset data from the UK to establish that a minimum birth prevalence was 1 in 5,000 births. That would be equivalent to 60 births a year in Australia. That's for both nuclear and childhood onset. It turns out that if the onset's in childhood, about a third of the time it's due to mitochondrial DNA cause, whereas if it's adult onset, about 70% of the time it's a mitochondrial DNA cause. So the best substantiated number is that for mitochondrial DNA disease, we know at least 1 in 10,000 people will be affected. I think a conservative figure is 1 in 5,000. Some people argue it's much more than that. And I guess the relevant thing is, if once mitochondrial donation has now been approved, I can't quite get out of the habit of saying if it's approved, what are the likely numbers that we might expect each year? And again, probably the best numbers come from a study from the UK looking at the number of women carrying mitochondrial DNA mutation in the northeast of England, and looking at the ages and fertility data, and they suggested that there might be 152 births per year in the UK that were at significant risk of mitochondrial DNA disease, which would equate to about 56 in Australia. That's not suggesting there will be that many women wanting to access mitochondrial donation, but that's kind of the number that best established number we can estimate. So the rationale for mitochondrial donation, the median survival of a child with mitochondrial disease has been estimated at 3 to 12 years. These are severe diseases when there's early onset. I've been involved in 3 Cochrane reviews, the last not yet published, but we keep concluding that at this stage, there's no clear evidence supporting use of any intervention in mitochondrial disorders. That's a really sobering statement. Very hard to get good quality evidence in rare diseases. For almost all other inherited diseases, prenatal diagnosis or PGT can enable couples to have a healthy child genetically related to both parents. But these techniques are not suitable for women at high risk of having a child with mitochondrial DNA disease. In other words, if the woman appears to have a substantial load of a mitochondrial DNA mutation. From the health economic aspects, the US estimates suggest any child with an inherited rare disease has a lifetime cost to the healthcare system of maybe $5 million. And the UK health economics supported mitochondrial donation as saving money in the health system. So just to emphasise, this is not a cure or treatment for existing patients. It's not relevant to any nuclear DNA diseases. It's a form of ART, an assisted reproductive technology, that seeks to replace faulty mitochondrial DNA in the egg or zygote to prevent mitochondrial DNA disease. So my last 2 slides, I just demonstrate the 2 main methods that have been reported. The first is called maternal spindle transfer. It's done on the unfertilized eggs, on a mature unfertilized egg, when the mother's nuclear genes, so 23 chromosomes, a haploid genome, 23 chromosomes arranged on this meiosis II spindle or maternal spindle, that can be removed from the mother's egg and inserted into an enucleated donor egg, which is then fertilized with the sperm. And within a few hours after fertilization, the pronuclei form, the male and female ones. That zygote will, if it develops normally, will divide in about 24 hours to become an embryo, and within about 5 to 7 days, Megan is much more qualified to comment on these numbers. It'll be at about the stage of 100 to 150 cells as a blastocyst and can be implanted. This is what it looks like under a microscope. You can visualize that spindle. It's a little bit trickier than for pronuclear transfer, but it can be visualized and removed. And this is from macaque monkeys. And here are the spindles surrounded by a bit of plasma membrane. They don't have their own membrane around them as they've been removed, and the so-called cytoplasts or enucleated eggs. So Shukrat Metallopold's group in Oregon showed in 2009 that using MST on macaque oocytes, they found no impact on the developmental potential of the reconstructed oocytes. So at 8 to 10 days after fertilization, the proportion going to blastocysts was the same as unmanipulated embryos. They implanted 15 of these MST embryos into 9 recipients. 3 healthy monkeys were born at the time and a couple more since. They're now middle-aged, and one was sacrificed a year or so ago to be able to study the tissues and the distribution of the mutation. At the time, they found no detectable carryover of mitochondrial DNA from the mother's egg, if you like, although they couldn't have detected anything below 3%. So there typically is the order of 1 or 2 or 3% carryover. And in terms of human studies, this is a technique that was used in the cowboy IVF approach, where a New Jersey group performed this technique in Mexico because the rules supposedly allowed it. So a baby has been born from this technique, but with very little data published. There are also reports of it having been used as an IVF approach without any real data substantiating that in Ukraine and Greece. And the thing to note, which might come up when Chris is talking, I think, is that there is concern that the data on human eggs suggests that the human spindles may be more fragile than in macaques, and that there may be a greater risk of chromosomal abnormalities with this technique in humans. So the other technique is pronuclear transfer, really driven by the UK team led by Mary Herbert and Doug Turnbull. So here, the mother's egg is fertilized with the father's sperm. About 6 hours after fertilization, the 2 pronuclei are removed, inserted into an enucleated zygote and allowed to develop and implanted. So it's a bit easier to see in these images that you can visualize the pronuclei a little more easily, remove them, wash them, and inject them back in, wash them to try to remove contaminating mitochondrial DNA. So they're surrounded by a membrane at that stage. So initially in the UK, they were only allowed to use abnormally fertilized eggs from an IVF program to study the feasibility. They found no difference in embryo development at any stage up to the blastocyst between the manipulated and unmanipulated zygotes. Average carryover of the mother's mitochondrial DNA was less than 2%. So it was legalized in the UK in 2015, but not immediately able to be used. The Human Fertilization Embryology Authority required them to demonstrate that it worked well on normal human zygotes rather than just the abnormal ones. So they received final approval at the end of 2016. The first couples were licensed in 2018, and there's been a lot of talk about this has been going for 7 years in the UK. The reality is it's been going for now just on 4 years in the UK, with 2 years affected by the pandemic. So in terms of the numbers, it's kind of buried away, but you can dig through the HFEA and parliamentary minutes and find that as of November last year, 26 couples in the UK have been licensed and 8 treatments performed as of July last year. So I'll just leave you with this video of the pronuclear transfer method, which is pretty amazing. Taking out one pronucleus, coming back in to take out the second one, and then cleaning them up a little and injecting into an enucleated donor zygote. And I love the last bit where they're injected in and then sort of tuck in the zona pellucida around the outside to put them to bed. So I'll stop there and stop sharing. Thanks very much.
So I'm going to take the microphone now. So hi, I'm Megan Munsie. I'm from the Melbourne Medical School, but also from the Murdoch Children's Research Institute. And I want to introduce some of the considerations around the law. And as Paula indicated, this is a much longer conversation that we probably need to have, but I want to get the conversation started by stepping back in time and acknowledging that the reforms that have just been introduced are really addressing the 2 acts that were first passed in 2002, so almost 20 years ago. And these acts were introduced really because of developments that had happened around the end of the 1990s through cloning technology. So that's somatic cell nuclear transfer, of which mitochondrial donation is a technical version of, and I'll come back to that point in a moment. And of course, the discovery of human embryonic stem cells by Jamie Thompson. And you can see both these 2 events were front cover of Time. Of course, there was also a lot of community interest and, dare I say, concern around developments associated with IVF. And David's introduced you to some photos of a fertilized egg, for example. And this is a blastocyst. That's the stage of development David was referring to, about 5 to 7 days after fertilization. So these laws were introduced in 2002, and you may well remember there was a lot. This was during John Howard's prime ministership, and there was a lot of community debate and discussion at that time. And there was also a conscience vote. It boiled down, at least from my particular interest in stem cell biology, to allow explicitly the use of donated excess IVF embryos. So these were sperm egg fertilized embryos that a couple originally had created in an IVF laboratory because they were seeking to have a family. They then no longer required these embryos for various circumstances and consented to their use. In order to use such an embryo in research, a researcher would have to apply for a license, and that was to the National Health and Medical Research Council Embryo Research Licensing Committee. So that was all established within this act to permit this form of research. But what it explicitly banned were many other acts. And I'll just go quickly through them, but I think it's worth remembering it did ban somatic cell nuclear transfer completely, so human cloning, the transfer of a cloned embryo into the womb of a woman or an animal. You could not use embryos or create embryos for research, but you certainly couldn't use these excess embryos without a license. That embryos were not to be cultured more than 14 days. There were restrictions around adding animal cells into human embryos. You couldn't genetically modify embryos or gametes. And of course, most pertinent to this discussion, embryos could not be created with genetic material from more than 2 people. You may well remember that there was a clause in that first piece of legislation that required an independent review to be completed 3 years after its assent. And this review committee was chaired by Justice Lockhart, and the committee report was tabled in Parliament in December and called for 54 recommended changes to the law. And I was heavily involved in this at that time because I was very keen, together with colleagues, to see perhaps a more nuanced discussion around cloning and somatic cell nuclear transfer to allow the creation of embryonic stem cells. And indeed, that recommendation did go through. But just to go back through the technology, again, this is schematic and not quite as pretty as that lovely video David just showed, but you can see that the manipulation technique is very similar. You first take a donor egg, you remove that metaphase spindle, so those maternal chromosomes, you then create that cytoplast, you take a nucleus from a somatic cell, a body cell, and you put that nucleus into the oocyte and then trigger embryonic development, isolate stem cells from that, and then go on and use that perhaps in research. So that legislation was amended, reform was introduced in 2006 by Kay Patterson as a private member's bill, and again as a conscience vote. And in fact, what that amendment allowed was not only excess IVF embryos to be used in licensed research projects, so again, through the NHMRC Embryo Research Licensing Committee, but also the creation of somatic cell nuclear transfer embryos only for stem cell derivation or for laboratory research, not for reproductive purposes. And hence the name of the legislation was then also updated. That reform also called for the law to be reviewed. And I believe there's a bit of a slow start. It didn't get reviewed within the 3 years, but was reviewed in 2010 with a report tabled in 2011, this time led by Justice Heery. And as you can see from the headline of the article in The Australian in 2011, the laws remained unchanged. So there was no appetite for change. And I think if we look at the quote, or the relevant section of the Prohibition of Human Cloning for Reproduction Act, you can see that this is the restriction that prevented any mitochondrial donation research or even contemplation of clinical application in Australia. And you note that the penalty was imprisonment for 15 years. I just point out that, as David mentioned, the UK did go on to introduce change to their legislation in 2015, but they did start that conversation back in 2011, about the same time Australia had decided not to, or the Australian consultation had decided not to pursue a reform to allow something similar in Australia. If we then jump forward to what's happening in Australia, and perhaps triggered by that development in the UK, where the UK HFEA, which is the equivalent of the NHMRC Embryo Research Licensing Committee, allowed for researchers to start doing this work under license in the UK, we started to see a very prominent conversation happening in Australia. And as David has acknowledged, a lot of that, the trigger for that was the call by the community, by those who are affected, to allow this application. And I just note that this graph from the website called in March 2018 for the Senate to look into, through the Senate Community Affairs Reference Committee, to look into various aspects around this technology, the ethical, the scientific justification, how the law would have to be changed, how the community could and should be consulted. And so that there was a scientific report tabled in June of the same year. And then after that, there's been a series of community consultations, of forums, public forums for participation, as well as an expert working group of which David was a member, and perhaps he was, I think he's probably involved in all of these activities. But there was quite a lot of consultation and consideration around how to repeal this particular provision. And in February of 21, the Prime Minister announced that there would be a conscience vote, and legislation was then introduced by Minister Greg Hunt, the Health Minister, to the House of Reps. And I just want to quickly go through what the reforms were outlined. I think it's quite a beautifully crafted piece of reform, and it's quite intricate in how it does repeal that section 13 that I shared, and relevant sections within the other act. But I just want to make the point that it's very clear in the reform that the only time that this technology would be or could be applied legally is when there are no other options for a couple seeking to have a biologically related child to reduce the child inheriting the mitochondrial disease, which is likely to have a significant impact on them. So that is quite upfront and explicitly stated. There are some specific licensing arrangements, again, utilising this Embryo Research Licensing Committee that has been in existence since 2002 legislation. Of course, the provisions allow for embryos to be transferred to the uterus, but only to achieve a pregnancy for the woman, but only under a licence. As I'll go through in a minute, there are some restrictions around types of manipulation techniques to be used. There's specific donor consent provisions. There are reporting requirements by the licence holder, as well as to Parliament through the Embryo Research Licensing Committee. There is a requirement for a donor registry that will allow a child created from this technology to be able to contact the donor once they turn 18. There is also provision for a clinical trial to support the evaluation of this technology. And there's clarification that mitochondrial donation is not captured under the Gene Technology Act. So I just wanted to go through two specific changes just to illustrate, I think, the thought behind them and how they'll be applied in practice. So I'll draw your attention to this subsection, which talks about the licensing. So under the current or under the previous law, as I mentioned, you had to apply for a license if you're a researcher and you wanted to use a human embryo or create a somatic cell nuclear transfer embryo. You would have to apply to the licensing committee for a general license. There is now a specific mitochondrial donation license, and there are 5 subtypes. And I think it's just worth noting that the first 3 are applicable now and perhaps for the next 10 years. Stage 2 is not going to be envisaged until a clinical trial has been completed in Australia and has provided sufficient evidence to justify this technology being adopted as a general clinical practice. Even if it was in stage 2, there will have to be still a licensing process. So you can see it's going to be highly regulated within its implementation. David's also already introduced the 2 different technologies, metaphase spindle transfer and pronuclear transfer of a fertilized egg. And I suspect Chris will talk a little bit more about these differences from a more ethical perspective. But I just wanted to point out that for the clinical trial license, the only technology that you could apply for is either of these 2. However, for the preclinical work, for a license under category A, there are 3 other types of transfer. I won't go into them today, happy to answer that in a question, that are seen to be perhaps not have as much of a strong evidence base, but still be worth exploring. So just bear that in mind. What I like about this aspect is that it recognises that this technique is not simple. As I said, it is a kind of evolution from techniques used in somatic cell nuclear transfer. And I think it is possible to get trained up relatively quickly, particularly if you can learn from others such as the UK groups and others abroad, but it will still be technical. And this new subsection recognises that, and you can only apply for a category C license once you have completed the above 2. So I think that's a really good safeguard to make sure that those who are license holders are technically competent. And of course, that will also preserve and reserve how many eggs are used in development. So I wanted just to finish up by saying that whilst I've highlighted some of the changes, the major reforms that are within Maeve's law affect these 3 top bills. But of course, there are some minor amendments associated with the Freedom of Information Act and the Therapeutic Goods Excluded Goods Determination. And I'll just make a final comment to say that I have stayed at 17 years, noting David's comment earlier around how long the UK have been operating. But if you remember, I talked about the Lockhart Committee report at the beginning of my presentation and how one of the recommendations was around somatic cell nuclear transfer. And I think that was recommendation 25. 26 immediately following was to allow research use, or at least research application of mitochondrial donation to allow Australian scientists to explore. That recommendation was made in 2005, and hence 17 years since until we see a reform. Just to finish off, of course, in the House of Reps, there was rigorous discussion and debate. The amended bill was passed on the 1st of December 92 to 29. It was introduced the next day in the Senate. The vote, of course, didn't occur till last week on the 30th of March, with a passing of 37 to 17. And as Paula mentioned, assent on the 1st of April. I was going to finish off by saying on the weekend, I did note this article and many others, and Peter Credlin's blast around how the quiet passing of Maeve's law. And I point out that perhaps whilst it might have passed Peter by, I think there were, as you could see from earlier in my presentation, there were many opportunities for community consultation and participation. And the people who participated in that admittedly were predominantly those who were affected by the disease. But I think there were many opportunities, and certainly in the Senate and in the House of Reps, we've seen very strong opposition to elements of this law, and I think we've had a very robust debate. So I will now hand over to Chris to discuss some of the ethical considerations.
So thank you very much to Megan and David. I think we've had a good run so far of going through some of the science of mitochondrial donation and some of the legal context and the journey we've got here. And I'm going to go through some of the ethical issues. So mitochondrial donation is always seen and described as a controversial biotechnology. The coverage of it often describes, 3 biological parents, this controversial new technique. So what this process has been is really a great opportunity for people like me that are interested in ethics to look at the role different ethical arguments, different ethical principles are playing in the debate, and looking at how these ethical arguments sort of go to influence policy. So what me and my group are currently doing a more sort of robust process where we're going through the public submissions and doing a qualitative analysis. That's been led by a med student, Jemima Allen, and also my colleagues, Danya Beers and Julian Copeland. But today, what I thought I would do is just going to give you, a little sort of oversight of what some of the ethical issues that seem to be imported in the submissions, and then how these were sort of taken up in the Senate debate and what seemed to be important. Okay, there we go. All right, so we saw in those numbers that Megan gave that there was overwhelming actually support among the senators and House of Rep members for the passing of Maeve's law. And it seemed to be that a really big driver of this support was the realization of the harm that mitochondrial disease is causing, the suffering that it's causing to people and the families that have mitochondrial mutations running in their family. This can just see as a general ethical sort of issue. We think that we have duties to reduce rates of harm and death in our community. We think we have duties to reduce the rates of death in future generations. And indeed, there are human rights considerations with this too, that people sort of have a right to health. But beyond this, you can see these sort of justice considerations playing up too, that, when you're making a law, when you're making a controversial policy, it seems to make sense to listen to the people who are going to be affected by the passing of that law the most, the people who are the most affected by the law. And in this case, those people were strongly driving a push for legislative change to allow this technology. And we could see the sort of patient advocacy group, the Mito Foundation, really leading this drive, showing that families suffering really want the laws changed. And I think this really strongly affected a lot of the senators and was a leading court consideration. Beyond just thinking about the families and the babies that are sort of affected by this technology, we see other considerations for some of the doctors and the pediatricians who have to sort of deal with the devastating effects of this disorder in their work life. So we saw that that was a driving consideration. I also want to mention that again with these ethical controversial technologies, besides listening to the people who are most effective, maybe we should listen to what the general public sort of think about and how the general public make these sort of ethical trade-offs that are at the heart of these types of technologies. And I note that a lot of the delivery democracy process, including the one run by Ainsley Newson, who I think I saw in the audience before, showed that there was some caution, but the majority of Australians supported this type of technology and supported its opportunity to reduce rates of disease. So what were some of the sort of concerns that were listed about the technology and that maybe drove some people to sort of vote against legalizing it? There's a lot of concern about, well, I'll just say sort of risk, the risk of the technology. And I'm going to break that down into two types of risks that were appealed to through this process. So the first of all, I'm just going to call it a standard risk, because we know that when we have a novel technology, novel medical technology, we need to make sure that it doesn't harm the people who we're treating. So this is sort of standard sort of medical risk. Now, this is not ethically controversial. No one would be sort of arguing for a very risky procedure that sort of harmed people when they had it. So this is a well understood risk that can be handled by traditional ethical processes like an ethics review panel. These are the types of risks that we sort of focus on. The main sort of, I think, standard risk, besides the medical risks that will be looked at very closely as part of the clinical design, the clinical trial design that this legislation allows. But I wanted to mention it, the sort of 3-person baby kind of risk that you see in the newspaper headlines, and you see in the, in the sort of, just that the way to sort of politicize it. Obviously, that's quite a misleading label. When we think about parents, we think about sort of social parents. A lot of the people who have this technology will still have, a mum and a dad, or 2 mums or 2 dads, whatever it may be. It's not going to affect the sort of social parent that we get. But we get this other alluded to risk too, that just combining the DNA in this way is going to be a risk to people. Again, you might think this is hard to sort of put together because DNA isn't normally person specific. So in a way, I've got the DNA from my mum and dad, 2 people, but I've also got DNA from 4 grandparents. I share DNA with my 3 brothers. So all of these things about DNA not belonging to people, and it's hard to sort of pinpoint what the sort of risk might be of these technologies. If we move away from just consideration, the sort of standard risk, so the risk to the people that will have access to this technology, and the risk of the people that will be, the children that will be brought up, we see also appeal to these broader types of risks, so these risks to future generations. So I've got 2 senators who sort of appeal to this when they were giving their speeches against the passing of this legislation. Christina Keneally, who appealed to the idea that we don't know the effects of this technology on future generations, and a similar concern by Senator Don Farrell. I think it's really interesting to look at the particular language that these senators are using, because we'll often talk about risks to future generations, but we'll do it in the context of climate change or something where there's a risk of harm. So we know that climate change is a risk to future generations, but we also know that it's unpredictable, and that is sort of the reason why we need to take it seriously. The language here is not, really about a risk of harm. It's just a risk of the unknown. It's that we don't know what this technology will do, and maybe that is a reason not to pass it. But that seems not a great legislative principle. We can think of all types of cases where new technologies will have an unknown or unpredictable effect on future generations, and that isn't reason itself to sort of count against them. Case in point is just IT technologies. If you think about how sort of social media and mobile phones are changing the world, and how unpredictable that effect is on future generations, but that isn't a good reason ethically to sort of ban them or to keep them banned. And I think this is a case in point in that Senator Claire Chandler's point that although we might think that some of these technologies might be harmful, they might also be really beneficial to future generations. And she points to the protection of future generations against this sort of harmful disease. So one concern that I'll go through quite quickly is a concern about designer babies. So the idea is that this technology might allow people to go beyond just editoring for health for mitochondrial. So Senator Matt Canavan brought this up in his speech when speaking against the passing of this bill. I'm also concerned about the broader ethical considerations of using the same technology to tackle other diseases or afflictions. or even ultimately to look at heritable traits around the attributes, height, strength, and other things. So I think this kind of concern is a concern that sort of links mitochondrial disease to gene editing. So gene editing is a technology that allows you to genetically modify all sort of parts of the DNA, to change a vast number of genes, which can then give people control over potentially give people control over people's sort of personal sort of cognitive sort of characteristics. But this simply sort of isn't possible with mitochondrial donation. So we know that mitochondrial, it doesn't give you fine control of personal characteristics. We know it's just sort of the engine house for the cell, as sort of David put it greatly in his point. So these concerns don't really catch, but you might be worried about something else. You might be worried about maybe this is a slippery slope. Maybe if we pass mitochondrial donation, then we'll be on a slippery slope to passing gene editing legislations. But again, I think we should resist this type of thinking. As Megan just said, this legislation took 17 years or something to come to part. It was a very careful process that included a lot of community consultation. So, 17 years to make a, precise legislative change doesn't sound like a very slippery slope to me. It's very, very slow going. So another sort of powerful concern for some of the, that's present in some of the submissions, but that was also influential with some of the senators, is a concern about creating embryos for this purpose. So we would have seen in David showed the two types of procedures that would be legalized with this law. And we saw that one of them involved the creation of embryos, the pro-nuclear transfer technique. For some, this will be a sort of ethical line that won't be crossed, particularly if you've got a more religious sort of ethical perspective. So Christina Keneally showed that this was a main concern from her. For me, creating embryos is moral Rubicon I cannot cross. But I thought it was interesting, the next part of her speech, where she tried to distance mitochondrial donation from sort of other technologies which allow the sort of creation of embryos for health-related purposes, namely IVF. So she says that the key difference is intention. In IVF, we are not creating an embryo, new distinct human life for the sole purpose of harvesting, experimenting on it, or destroying it. So I think that can be, it's obviously a very sort of complex issue, but what we might think about, well, really mitochondrial donation, we do have the intention of creating life, the same as IVF. We have the intention of creating a healthy child. And this is quite similar to other technologies. And perhaps a good analogy is, rather instead of IVF, is clear implantation genetic diagnosis, which is another technology that we've been using in Australia for decades. In this, we create a range of embryos, but knowing that not all of the embryos are going to be implanted. So when we do this, it is, again, the generation of embryos for a health-related intention, knowing that not all of the embryos will pass. But anyway, I should say that I'll come up to the end. There were lots and lots of different sort of ethical issues that we could go on and that were drawn on, but this is sort of a bit of a snapshot of some of the ones that seem to be important in the process. I'll just give my personal conclusion that I thought this was a really good example of how to make policy in ethically contentious areas. I really liked the different stages and the diverse range of evidence they got, but for me, it was quite clear that the evidence strongly supported the passage of Maeve's law, and in particular, the two-stage steps. So I think it's important to stress that what's been allowed is a clinical trial. It's a clinical trial to allow us to assess safety and other things, and this is really a small step, I would think, and shouldn't be so controversial. And I will end now.
Thank you very much. Thank you to David, Megan and Chris. That was wonderful. Have we got some questions or comments from our audience? We have about 8 minutes. So thank you. Liz.
Thanks very much to all three of you. My question's to Megan. I understand that the UK legislation explicitly precludes donor recipients from finding out who the donor was, whereas I think one of the slides said that our legislation specifically sets up a registry to allow this to happen. I just wondered if you could comment on how that developed within the legislation. Was it a sticking point? Did it go to, forward and back? Did it have any context in Narelle's law? How did we arrive at somewhere different to the UK on this?
So thank you very much, Liz, for your question. I'm going to ask David to chip in because he's much more familiar with the UK law and perhaps some of those machinations. But I think this discussion has come after so many of the discussions around other donor gametes. So I think it within Australia. So I think that was certainly set the tone of the conversation. And I think it was a sensible suggestion. There's some issues, I think, around, we haven't even really talked about access to donors, but I think it's very different from, I think we should be also remembering that donating eggs to mitochondrial donation is probably going to be a very different scenario to donating gametes. So I just park that comment there and just quickly throw to David to see whether he wants to add anything about the UK.
I see Ainsley Newson's made a comment in the chat about UK being more voluntary, not condoning legislation in the UK, but there's room, as I understand it, for voluntary registers. My impression is that this is a slightly cultural thing about the way IVF and ART have developed in Australia versus the UK. And in the UK, they did not regard donation of mitochondria as implying parenthood, if you like. Whereas in Australia, the role of the donor is seen at a different level. And this came up to me for the first time in the 2018 Senate inquiry when it became apparent from a number of sources that in Australia we would expect that sort of registry to be available. So I don't know, Ainsley may have more insight if she wanted to comment, but it does seem a cultural thing almost between the way IVF ART is delivered in the two countries.
Mm. I can jump in very quickly if you like. I don't want to take up the whole discussion. Hi, Liz. And thanks, David and Megan. I totally agree with your summary. I think that the only thing I would add is that David's point around the framing of mitochondrial donation was very different in the UK than it has been here. And I think Australia has really been a global front runner in access to identifying information about donors. And I think it was felt that it would be a backward step to somehow make this different. But I think in the UK as well, the drive for making oocyte donation for mitochondrial donation anonymous was born out of a concern for numbers of donors. I think they put that in place as a protective mechanism because they were concerned that people might not otherwise come forward. And in Australia, it just didn't seem to be a concern. So that possibly explains the distinction between the two jurisdictions, or it goes some way towards that.
Thanks very much.
Do we have any other questions or comments from the audience to our panelists?
I can ask a question of my fellow panelists.
Okay, Chris.
One thing that I didn't talk on, but is an ethical concern, is the role of sort of sex selection plays in the provision. And, there has been talk that in some jurisdictions that they will limit it to male offsprings because they go past the mitochondria to future generations. My understanding is that was defeated in an amendment, but if you guys can give maybe more sort of clarity on that sort of aspect and how that was handled in the Australian context, that would be great.
Yeah, and so I'm going to start and then throw to David again, because I think it's a really interesting point, Chris. And of course, it was part of the, it was described initially in the first reading in Maeve's law as part of the conversation you'd have around options. So it wasn't necessarily mandated. So other jurisdictions, such as some states in the US have just, or some reports in the US have talked about the fact that to avoid inheritance, to avoid that risk of passing on even carrying over a little tiny bit of contribution of diseased mitochondria, to future generations, you only allow male embryos. So that obviously requires sex selection. But here it was raised as a possibility, part of the rich number of things you would talk about as part of the kind of counselling associated with embarking on this journey. And as you alluded to, Chris, it was an amendment that was voted on in the House of Reps. And David, I'm going to throw to you now, because you probably have a little bit more context around some of those deliberations.
Yeah, no, I mean, you're right. In the US, the inquiry they had in 2016 made a number of recommendations. They took a different view from the UK and essentially from Australia that mitochondrial donation was germline genetic modification, but that could be considered differently to any other forms and considered ethically as potentially appropriate. They had concerns about safety and recommended that it be only restricted to generation of male embryos. I had a lot of discussions around this with the UK, and their view was that it's possible to do there, but effectively to do it efficiently requires a second go at the embryo, and that's not thought to be a terribly sensible thing to disturb the embryo for a second time. I mean, you could try to enrich for male embryos by centrifuging the sperm and so on, and so it was in the initial discussions, and to me, things like sex selection and haplogroup selection, which, there's some concerns that have been raised about whether you should try to match the mitochondrial DNA as closely as possible. And to me, those things seem like things that should be discussed with parents so they knew about potential risks with the best information at the time. But yeah, it was put as a modification to get rid of it because it was discriminatory, really, rather than anything to do with safety, I think. There were a lot of discussions that went on between the Mito Foundation, government advisor, myself and some others, and we decided not to oppose that because we saw no practical concern with it, and it was felt that giving in to one or two of the amendments might show some willingness to consider input.
I think just following on from, and thanks for the comments in the chat, Ainsley. I think your comment, David, was really interesting around having another go at the embryo. Just to be clear, it requires, again, pre-implantation genetic diagnosis to take out a blastomere of that blastocyst stage of development. And it also assumes you have multiple embryos to choose from. So, when in the old days in IVF, we used to grow embryos and put them back at day 2, which is when there are 4 cells and maybe somebody would have 10 embryos. But blastocyst development actually does whittle down the number of embryos, probably therefore increases your chance of pregnancy because you're putting back a high quality embryo, but it still means that it's a numbers game. So it's a big ask, I think.
Well, thank you to our panelists, and thanks everyone for joining for this discussion today. It's such a timely discussion, and obviously there's a lot more that we could talk about in respect of it, but I'm so glad that we've had such 3 expert panelists to start the conversation since the law has passed. So the Health Law and Ethics Network will be holding another seminar next month. So we always aim for the first Tuesday of the month unless there's Easter or some other public holiday. And next month we'll have Professor Julian Savulescu from the University of Melbourne. And Julian's going to be talking about the use of AI in medical decision making, particularly in the context of IVF. So we look forward to another great topic next month. So if you can join me in thanking our panelists for today, and all the best until we see you next month. Thanks very much, everyone.